Welcome to the podcast, Darren Heitner. Thanks so much for coming on.
Thanks so much for having me.
All right. I'm jealous of the looks like the sunny breeze behind you. The rest of the country, including New Orleans, is stuck in ice and snow and cold. But um, let's talk about. I thought I'd have you come on and talk about your favorite movies and maybe some of your favorite books. But you have been, I think it's fair to say, front and center in many of the biggest issues facing college sports right now at the D1 level with respect to eligibility and transfers and NIL contracts. And you've been very open about a lot of the issues you're dealing with, both in your newsletter and on social media. And I want to talk about some of that in a bit, but maybe help us understand with respect to these rev share deals or NIL contracts or just the money that's being spent by the institutions directly to the athletes, where the schools are paying the athletes pursuant to the House settlement. Can you tell us what, in general, I know it varies, but in general, those contracts look like and what are some of the key terms?
Well, first of all, since you asked, favorite movie is Billy Madison and favorite book is Atlas Shrugged. So I'm really on
Oh,
both ends of the spectrum there.
all right.
The
I'll
the
look for
the
that
rev
crossover. It'd be a great Netflix if Billy Madison lived in Atlas Shrugged.
the revenue share money, which is currently capped at $20.5 million and is supposed to rise year after year over a 10-year settlement in the House v. NCAA settlement, is supposed to be used by the athletic departments across all sports and does not have to be applied for each sport. It's just that that is the technical cap that is supposed to be spread across. And what we've seen generally, and it does vary school to school, but the vast majority of that money is being applied for football players, followed by men's basketball players, followed by typically women's basketball players. And then sometimes it trickles down to baseball players or in some circumstances, women's volleyball players, et cetera. But what we find are that these monies are transferred or promised to players by way of what are commonly referred to as NIL license agreements. And schools do title them differently, school to school, and sometimes conference by conference. And in fact, when we look at it from a conference standpoint, there's one in particular that has taken a very strong position, that being the Big Ten, that has actually drafted a template at the conference level that it has pushed to its member institutions. And this has been the case over the past couple of years. Last year, most schools adopted a form of that agreement. This year, all of them, from my perspective, have. And this cycle, I'd say I've reviewed roughly 40 to 45 deals in the space over the span of December to January, which is a lot of work, obviously, and many of them within the Big Ten. And if we're focusing on that specific document to start, what's very interesting about it, if you look at it a year ago, it went out of its way to indicate that the payments that are being made to players are not payments for play. This year, there was actually an addition to that, which is that the deals are also not to be construed as service contracts. Whereas if you look at some other schools' contracts outside of the Big Ten, they actually do ask for players to provide services outside of simply providing a grant of a license to the institution. But that is almost always the first and paramount section of these agreements, which is a license grant to the institution that oftentimes has third-party beneficiaries, including the NCAA, the conference, and this year we're even seeing the College Sports Commission included as a third-party beneficiary in various respects, sometimes even including the grant of the license. And key parts of that, I mean, you get into obviously these are one-sided originally, and they're drafted by the institutions. So you commonly see the license being irrevocable, oftentimes exclusive, and that it's sub-licensable, and oftentimes without any consent required by the athletes for any of the licensing use or even the sub-licensing. Um, and this can obviously pose issues if there's conflicts between the sub-licensing and deals that the athletes are doing on their own or through their agents. But interestingly, even in this go around, we're seeing a lot of contracts allow the schools to license it to agents, and
Right.
that includes multimedia rights holders, but oftentimes isn't limited to that. And a lot of these deals that are passed on to me are passed on through agents, and that's oftentimes a concern of mine, which is if we're providing these rights to third parties to try to procure opportunities for these players, what about the agents who have actually signed exclusive representation agreements
Right.
with those players? Outside of the grant of license,
Wait, so
big ish. Yeah, go ahead.
yeah, on that, let me just pause on that for a second because there's a lot there, and I just want to
Hmm.
clarify something about why, or maybe emphasize why these contracts have become tricky and why the issues in the lawsuits may become tricky is under the House settlement, as you said, the schools are now permitted, not required, but permitted to pay up to this year 20.5 million ish, 22% of this defined set of revenue. But the NCAA made pretty clear throughout the House settlement and the approval hearings that this is not pay for play. This is a share of the revenue that the schools generate that can be distributed directly to the athletes, and the schools can do third-party NIL deals that are not subject to the cap. And then the really a question that was raised was, all right, if a school decides I'm going to pay $1 million to my quarterback as part of that $20.5 million, and I'm going to enter into a contract with them, what are the terms of that contract? And it sounds like what you're saying, at least for the Big Ten, it's styled as an NIL deal where it's a grant of a license to use the athlete's NIL by the school and then by their anyone who license it from them, but that it's really passive. It's just we get to use your name, image, likeness. You don't have to do anything. And then there are these other schools that require services to be performed, but those services are not the playing of the game, right? Those services are doing an NIL appearance or doing an endorsement, not an endorsement deal, but making an appearance, signing autographs. Is that all correct?
That's accurate. And in theory, that's what these are. They're NIL license agreements, or in the case that a school is asking for some services, it's not supposed to be pay for play. And that's certainly the intention of these schools and at least the Big Ten Conference, and that's why they're titling the agreements as such and including the grant of license as Section 1. But when you read between the lines, they can only go so far because despite saying that there's no pay for play, when you have language that includes things like there has to be good standing, or not even that definition, but otherwise saying that an athlete has to be, let's say, on the roster, so then what does it really matter? Obviously, it's not just the grant of license there, but if you can revoke having to make payments, or let's say if a player transfers to another institution or stops playing altogether, that there's a clawback mechanism or what they oftentimes refer to as liquidated damages that I think any lawyer looking at it plainly would question whether they're actually intended to be a reasonable estimation of the damages or a penalty intended to restrict movement from one school to another. That's where you get into the weeds, and I think you have to ask a lot of questions. And interestingly, I recently had a hearing in front of a judge in Florida on an eligibility matter concerning Dr. Bradley, who was the SWAC Defensive Player of the Year, preseason Defensive Player of the Year going into this season, but was denied an extra year of eligibility. And during the course of a 2-day evidentiary hearing, we started to get into the weeds of these NIL agreements, and the judge asked a question along the lines of, aren't these supposed to be NIL agreements? And I talked about how there are all these other requirements involved that make them seem like employment agreements, and he kind of even said, oh, so it's like wink, wink, these are NIL agreements, and he's like, what are we waiting for? And I said, probably a judge sitting in your chair to make a determination. And so when you look at these documents, again, you look at the title and it says NIL license agreement, you look at the grant of rights, but when you read through the document, you look at the various options for the school, oftentimes in its sole discretion, to be able to terminate, to be able to invoke liquidated damages, to be able to invoke clawbacks. And not for any breach of the license, not for failure necessarily to perform any of the non-play services, but because they actually want to perform for another institution, you have to question what really is this document all about?
Right. And then I want to get into, and again, you are representing some folks, including Darian Mensah, who are involved in active litigation. So I'm not going to ask you about the active litigation. But so anything we're talking about is going to be either broader than that or maybe a case that's already been resolved. But again, not asking you to speak about that specific case. Um, but if you take it out of the college sports context, and let's just say put it in pro sports or put it in acting, if you have an actor who is the star of Pluribus, right? One of the big new
Great
shows
show.
that's out there. Yeah, I'm only on episode 3, so no spoilers. But if you have Rhea Seehorn, who's the star actress in that show, and um, Haynes says, we want to sign you, Rhea, to a endorsement deal because of your success on Pluribus and Better Call Saul, and you've become a star, and we're going to pay you $1 million a year as long as you're still on the show. But if the show gets canceled or you get fired, we're not going to pay you anymore to promote our product because the value in your NIL will have decreased significantly because even though we're not paying you to act, we're paying you based on the fame you have received or will continue to receive because you're acting. And so there, I think we would say, right, that's not doesn't have to be an employment agreement. That could be a regular endorsement deal that is contingent on a continued level of success. And so that maybe the teams, the college teams are thinking the same thing, that if they're not on our team, if they're not playing at the same level, they're not as valuable to us. So we're not going to pay you, or we're going to pay you less. But what seems to be different than what Haynes and Rhea Seehorn, I don't think they actually have a deal, but if they do form a deal because of this, great. But what's clearly not happening there with Vince Gilligan and his team is saying, we are trying to prevent you from going to work for another show.
That's right.
And that appears to be from all illustrations we've had and from the 100 years of history that that's what the schools are trying to actually accomplish is saying we want to pay you for whatever it is. We'll call it your NIL, but really we want you to be here playing and we don't want you to go somewhere else and play. And if you do go somewhere else and play, we can argue maybe your NIL is not worth as much to us, which I think most people would agree that if you are a Syracuse athlete and then you go transfer to Cal, that it's not as valuable to Syracuse, or your image is not going to be as valuable in Syracuse itself. But so tell me then what's
Yeah.
wrong with how the schools are going about this from your mind, even if their end goal is not unreasonable, that they want a player to play for them and not be able to leave in the middle of their contract and go play somewhere else. What is problematic with the way that's being handled now from your perspective?
I'm glad you added that at the end because I think from a normative standpoint, it's responsible and expected to believe that schools that are investing a lot of money in players want to do whatever they can to retain their services and not have them leave. But we've seen instances even where an athlete will sign a contract and not even get paid any money on that contract, yet there's a liquidated damages clause that may say that the athlete owes up to even 100% of the amount of money that was promised to the player. So think about that for a second. The player receives $0, maybe signed for 3 days, decided, you know what, this is not going to work for me. And the school wants $1 million because that's what's been promised to the player. And there's no equity in that. It's hard to rationalize that, and we haven't seen a lot of cases that have developed and escalated for a good reason. I think if push comes to shove, those are going to be very difficult to defend as actual liquidated damages as opposed to penalty clauses. But the other issue is, last year, your question channeled some memories for me. Last year, in some contracts, we would even see language that said schools in their sole discretion could actually change the amount of compensation that was allegedly guaranteed to players and reduce the amount of compensation to be paid to the players because of a perception or belief that the value of their NIL decreased as a result of their poor or lack of on-field performance, which I thought was quite interesting.
Right.
I haven't seen that in this year's cycle.
Yeah.
But you get to this issue of these look and feel like employment agreements with real restrictive covenants that normally in such a circumstance, if challenged, you would have to look at whether there's legitimate business interests to enforce those restrictive covenants to prevent movement of players. And certainly different states look at those types of restrictions differently. If you look at a state like California that's been very pro-movement, I think it would be extremely difficult for any of these institutions to enforce. Whereas my home state of Florida is a bit more employer friendly, but you still have to, as the employer, justify any sort of restriction by showing legitimate business interests. And then also that the restriction is reasonable from a time, scope, and geography basis. And from my perspective in looking at these clauses, which again may not overtly state that they are restrictive covenants or non-competes, they have the ultimate consequence of serving in that type of capacity when a player has to buy out of the contract in order to freely move from one school to another. And I think one thing that's also missed in a lot of these conversations is at the end of the day, we're still talking about students. I try not to use the term student athlete because I don't like its connotation, but they are students. They are seeking an education and looking oftentimes to graduate or get a postgraduate degree. And so I think there's also this oddity in this process, which is we're not only talking about restricting athletes from moving school to school to play their sport of choice, but we're also potentially impeding their choice on where to receive an education. And I don't, to my knowledge, that hasn't yet been tested in a court of law, but I imagine at some point it will be.
Right. And it seems like the way that some of these cases are playing out is that if it is truly an NIL deal and you're paying for the athletes the rights to use their name, image, and likeness in whether it's a commercial or whatever the case may be, or a poster, um, and then the athlete decides they want to go play for a different school, and the school argues, well, we've now been damaged, or you shouldn't be able to go, or this is the harm we've suffered. Where again, if you go back to my analogy of Haynes and Rhea Seehorn, that if she decided she wanted to leave her show and go to a different show, Haynes couldn't stop her from going to that other show. And they may be
Right.
able to say, we're not going to pay you anymore under the contract. But if they're not paying her to act, but paying her for the value in her acting, sorry, the value that has acting has generated an NIL, um, then that's a totally different story than what's going on here with college sports.
And that's a very interesting component of this as well, because you're starting to see in some contracts the introduction of injunctive relief.
Right.
And in order to, you could put a clause in any agreement where the parties agree that one may or shall have the right to enjoin another, and even have the parties acknowledge or represent that there's irreparable harm, but you still have to go through that process in a court of law and ultimately prove that. And so there's two components of that, which is one, like if there is a way to be compensated by way of monetary damages, then what is the irreparable harm that would serve as the justification? And there's other elements, obviously, public policy, weighing of the harms, et cetera, but and likelihood of success on the merits. But if you can't establish irreparable harm, I think the analysis just folds right there, right then and there. And so the other thing is when you're looking at at damages unless they are specified by way of let's say, a liquidated damages clause. And even if you have that, how do you actually justify what those damages are? I mean, if they are license agreements, which the schools are bending over backwards to say that they are, obviously to avoid any implication of employment. And in fact, oftentimes there's clauses in bold and italicized saying this is not an employment agreement. And if they're deemed employees, then everything's off the table. We're not paying you anything. Um, but what are the monetary damages if, let's say, an athlete goes from one school to another and the license is somehow interfered with? I mean, I think it would be really interesting to have an institution, perhaps through an expert witness, try to explain what those damages are and how to
Right.
quantify them, particularly because, as you know, broadcast NIL is not a part of this equation.
Right.
So you really can't preclude an athlete from playing for another institution unless a court says so, and then have those games broadcast because that's outside of this equation where the license is being granted. So what exactly is the license, and what is the monetary component of that license? Is it the jersey sales that contain the athlete's last name on the back? Is it some sort of memorabilia? But again, it doesn't seem like the quantification of that would be astronomical.
Right. And then even if it is astronomical, it's damages. It's an amount. And
Right.
to your point, then you wouldn't get the specific performance, or you wouldn't get the injunction to not allow the athlete to go play somewhere else because, all right, school, you get paid X amount to make up for the money you've lost from your licensing opportunities, whatever else it was that you plan to do with that athlete's money. Again, going back to the point of whether I'm not suggesting that these contracts should be read one way or another, but it certainly seems like from the outside that the goal of a lot of these contracts is to lock a player in. I don't mean lock like we used to lock a player in without any money, but to pay an athlete a certain amount of money to play at that school for 1 year, for maybe 2 years. And the school will now pay the athlete that amount of money, and the expectation is the athlete will stay there. Uh, and then if they do leave, then we might have a breach of contract situation. And there, not to say that the athlete has to stay, but if they do leave, then it would look more like what we're seeing with the coaching contract situations, where potentially someone could sue for an injunction. But what would most likely happen is we see these buyouts, either buyouts under the contract or there's a negotiated settlement. Do you see that? I mean, can you talk a little bit about the Williams case in Washington, where you were able to, without getting into the details of the settlement,
Yeah,
but we were kind of headed towards a lawsuit or potentially some judicial involvement before you stepped in.
that's right. And to be clear, there was no settlement because there was no escalation. We were
Right,
able to resolve
right,
that pre-suit, and I
right,
don't even recall that there was any real threat of litigation. But Damon Williams is a very interesting set of circumstances where everything, as is typical in this space, moved very quickly. And I recall, and it was a few weeks ago, but I had been contacted by his agent at the time, Doug Hendrickson of Wasserman, who had indicated that there was a situation that was developing, and he was going to recommend me to Damon and the family. And what had happened that week, I believe it was on a Tuesday, that Damon had published on his Instagram a message that ultimately stated he was going to move on from Washington. And he did so before ever putting his name or having his name entered into the transfer portal. And ultimately, as we've actually seen from a few Big Ten schools in particular thus far, Washington was determined to not put him in the portal. And here's another area where we could potentially see some litigation in the future because the Big Ten and some other contracts actually uh, cause the player to covenant that he's waiving the right to have his name be put in the transfer portal. The NCAA bylaws require all member institutions to insert a player's name into the transfer portal within 48 business hours of that athlete completing this academic exercise and asking to be put in. So
Right.
one important question is whether these institutions that are voluntary members of the NCAA can separately contract around the bylaws, which I had really never heard of before until this particular issue or any schools trying to do so. But I will tell you, Washington is not alone in terms of schools this cycle that have taken a very strong position, which is that if a player contracts that he's waiving that right to be put in the portal, we're not going to put you in the portal. And in fact, a year prior, I dealt with an issue with Xavier Lucas, who at the time was a defensive back at Wisconsin, asked to be put in the portal, was not placed in, and we found a resolution by way of unenrolling from Wisconsin and enrolling at University of Miami. But with Demond, it was really interesting because he had set this whole issue in motion when he published that post on Instagram. And personally, it never needed to be published. I've heard speculation as to why it occurred, but I remember it was that when the following day, Wednesday night, that I had actually connected with the family and then ultimately was retained on Thursday. And there were a lot of different issues at play, one of which, perhaps the most important, was there was a deadline on enrollment for the spring at Washington. And when I was retained, there was an intention to leave and go to another institution. And I took a step back and reviewed everything that was executed, had a lot of very important conversations with the family, with Damon, put a lot in writing for them to consider as to the positives and negatives of going to another institution, which would probably be by way of unenrolling and enrolling as we had done with Xavier Lucas. And that's probably why also I came recommended, given that I had gone through that process before. But also, I thought it was important to distinguish between what we had gone through with Xavier Lucas, where we had some time to consider the situation and also felt quite comfortable with what we were doing, as opposed to in this situation where there were a lot of unknowns. But at the same time, unlike with Xavier, where we didn't feel very comfortable with Wisconsin and he was destined to leave, Washington really showed a passion for Demond and that they were really interested in having him back and how much they expressed how much they valued him and would work with bringing him back into the fold. To complicate things, the timing of his Instagram post couldn't have been worse because it was at the same time that there was a service for a player, a women's soccer player who had unfortunately passed away. And so we looked at everything, and I'm thrilled. The family's thrilled at this point that he decided to go back. He's acclimating back into Washington, and we were able to avoid what ultimately could have been escalation in that matter, whether it be Washington against Demond for an allegation of breaching the contract, and it could have put to test that liquidated damages clause that we talked about before, as well as a possibility that Washington would have gone after any school that he would have ultimately enrolled at for. I know we oftentimes hear the word tampering in the college sports space. That's not really a cause of action for tampering, but perhaps tortious interference.
Right. Right. And then, so on that note, a couple of questions. One is you've talked a lot about this and you helped implement this with Xavier Lucas, but can you just kind of clarify for people what the transfer portal means in terms of athlete movement and what it doesn't mean? Because you've said publicly many times you can switch schools without going through the transfer portal. So can you explain how all that works together?
And it was actually one of the more interesting moments of my career when we put it in motion, and I think it was Ross Dellinger who had contacted the NCAA to get confirmation that this was okay, and the NCAA actually came out with a statement saying, "Yeah, there's nothing, there's no rule against unenrolling and enrolling elsewhere." So we felt super comfortable with that. I learned a lot about the transfer portal through that process. I learned it's actually just a piece of technology that was created and that is actually not even run or operated or controlled by the NCAA. It's managed by compliance officers around the country. And so, in fact, when I was dealing with the Xavier Lucas issue, and we had drafted a complaint and a motion for a preliminary injunction to file against the NCAA and Washington before coming up with this creative solution, I had obviously said something to counsel at the NCAA saying, like, can't you do anything about this? I mean, you have a rule in your bylaws that specifically states that a school must put a player in the portal within 48 business hours. And the NCAA's response was, it's our rule, but we actually can't require a school to do it. And the only thing that we can do is take retroactive action against the school and punish them, which to this date, to my knowledge, Wisconsin has not been punished at all for not putting him into the portal. And I think that's honestly empowered a lot of other schools this cycle to do the same and threaten players that they would not put them in the portal. I was involved in many circumstances where athletes asked to be put in the portal, they were not, and we negotiated buyouts with schools as a result of that because they also just didn't want to deal with the escalation and everything that comes from it. But
Right.
yeah, I mean, the portal is simply just a piece of technology, and importantly, the importance of it is that under the NCAA bylaws, if they are to be deemed enforced and enforceable, they technically restrict other schools from having communications
Right.
with players unless they go through that portal process. So the caveat is obviously if the player knows where he wants to go, and oftentimes even with the portal, players attach what are called do not contact tags. So players oftentimes know where they wish to go. And in those circumstances, in my estimation, the portal's sort of meaningless. Right now, at least for football, it coincides oftentimes with when a player would enroll at the next institution. And that's something for anyone to be cognizant of because the unenroll enroll concept doesn't work all that great if, let's say, you're doing it in the middle of the spring semester with the hope that you'll be able to practice with the team.
Right. And even if you don't necessarily know where you want to go, in theory, if you are a top player at whatever position you are and you decide to unenroll, at that point, I imagine some coaches will find you or some GMs will find you and say, hey, let's talk. That you might hear at least that there's going to be some competition for your services. So the transfer portal, again, even if you're undecided, even if you don't have a sense of where you're going to go or have had a not haven't had a coach reach out to you, it still might be an alternative to the transfer portal um, at any point, right? And the enrollment, unenrolling is one thing, as you said. You then have to worry about enrolling somewhere else, and if you can't do that in time, then that kind of defeats the purpose, or at least for that season or that semester.
Well, there's the difference between rules and reality.
Yeah,
And even when players go through the transfer portal, how many times do you think those top players that you're referring to
right,
had no conversations, either
right,
directly or through their agents prior to the portal opening, which
right,
technically is the same violation
right,
as unenrolling and enrolling and having those conversations with GMs or other individuals attached or associated with the
right,
institution. So
right,
that's the thing. I mean, we could have a whole separate conversation about enforcement. I referenced the fact that it's very clear Wisconsin last year violated the bylaws. Nothing happened to Wisconsin. It's very clear that on a daily basis, there's violations of these bylaws based on conversations that are occurring with players that are not in the portal and other institutions. Nothing happened as a result of that. It's very clear on the CSC side that many deals are going unreported and that many deals are being paid out even though they may not be cleared by the CSC. What's going to be done about that? And the maybe the biggest problem is, there's an intent to have all these rules serve as deterrence, but at the same time, obviously you can't have deterrence without enforcement. But then if you have enforcement, what are you going to have? Litigation. And so it's a catch 22 for the NCAA. It's a catch 22 for the CSC. I don't envy the position that they find themselves in, whether it's with respect to NIL or an equitable treatment of individuals who are seeking additional years of eligibility. But at the same time, this is the consequence of sitting on their hands for decades.
right. And I want to get into the eligibility in a second, but for the you mentioned the CSC. I want to just talk a little bit about because you've spoken about this too, the what CSC is trying to do and what they've been able to do and what they reported with again the goal being that there is that 20.5 million for this year that the schools can pay directly. Doesn't have to be for a valid business purpose, doesn't have to be fair market value. You can just pay it. It just is capped. And then there are the NIL deals that as long as they are for a legitimate business purpose, which has been debated, and for fair market value, which will continue to be debated, the athlete can do it without subject any cap. So that doesn't go into that $20.5 million. But part of what the CSC is designed to do, was created to do, is to make sure that those NIL deals aren't being used as a way to circumvent that $20.5 million cap, like has allegedly, reportedly, being investigated right now with Kawhi Leonard in the NBA, and is a basic feature of every collective bargaining agreement and salary cap and anti-circumvention provision. We don't have a salary cap collectively bargained here. We have it as a result of the House settlement. So that's, again, going back to your point that the NCAA is in a catch-22, that they're trying to enforce rules that they think are necessary, like pro sports do, but they're doing it without any antitrust protection, so they continually get sued. And now they're
Right.
also getting sued under contract law. But the other piece of this that you've talked about recently is the multimedia rights deals and how a school, whatever school it is, I'm not going to pick on a particular school, but a school says to their star quarterback, we know, or the high school quarterback, we are going to pay you $5 million. And we promise you we'll pay you $5 million. Now, 3 million of that, let's say, might come from their rev share, and they contract for that in that license deal. 2 million might be them saying we are going to get fine third party deals for you. And then this is where the MMR partners come in. So can you talk a little bit about what you've seen and some of the language that you've come across?
It's the comedy of all of this, right? You have to ask, so who really wanted the provisions in the House settlement that would create an artificial cap that, to my knowledge, has not been legally challenged to date, but is probably going to be challenged at some point because it wasn't collectively bargained with the athletes that are intended to be restricted in terms of the amounts that they can make. But you would assume that this was negotiated on behalf of the member institutions, and particularly those with power. And who has more power than the members of the SEC and the Big Ten? Yet those are the same institutions that are either still using collectives to try to, again, go above the cap and are utilizing interesting mechanisms in order to try to establish that fair market value and legitimate business purposes. Or the new technique that we're finding this cycle is exactly what you mentioned, the use of multimedia rights partners, and the biggest one being Learfield, but there are others. And when you look at these documents, they're structured as letters of interest and uh, very clearly not intended to be guarantees of any amount of money to athletes, but they specify an actual amount that is intended to be provided to that athlete through third-party deals that they would be able to curate with an approximation on that number. And by the way, it's not going to be difficult for any of these MMR partners to establish those deals because if you think about it, the money's there when they're doing these deals, whether it actually be money that the third parties, real brands will pay out, or that the boosters will supply. And then, so worst case scenario, let's say they can't find the brands that want to come out of pocket to pay for the rights of those athletes. All they'll do is get the money from the individuals, the boosters who will provide it, and then essentially go to the brands and say, look at this amazing deal I have for you. I'm going to either give you these benefits for free or at a greatly reduced price from what you would normally pay, because there's still the appetite to go beyond the cap and pay extra dollars. What's happened, though, is that practically all of these big schools have adopted this policy and strategy, and yet the same question comes out. Okay, so these are the people institutions that wanted the cap and the House settlement. They're also the people behind the College Sports Commission, because the College Sports Commission is paid for by the NCAA, by the conferences, and by the schools that opted in to the House settlement. So in theory, this is a creation that they want, but they're doing this on one hand with these MMR partners. And on the other hand, here comes the CSC that is saying, well, take a step back, put pause, because we're looking at these documents, and you can't warehouse rights, which is what you're doing by way of these MMR deals. And so we're going to count these against the cap, which would honestly make every single large institution immediately be in circumvention of the cap. I don't know. I mean, we're talking right now in such an interesting time, because I don't know what the fallout's going to be in all of this. I mean, what is the CSC going to do? It's going to, in concert with the NCAA, penalize every major institution throughout these major conferences. I don't see it. If that happens, they're going to break away. So going back to a comment I made before, it just seems like one cluster of a catch 22. You're on mute, Gabe.
Thank
There you
you.
go.
It also does seem like if those deals are rejected, right? If the CSC says no, you can't have that MMR money be warehoused and then spent on the athletes as if it's guaranteed. That seems like it's if anything's going to lead to another lawsuit, it would be that, because whether you are the school who, even if you've signed a participation agreement, even if you don't have standing to sue, the athlete can sue because they've settled. The third party hasn't is not a party to the settlement, so they could be the ones to sue to say, I don't care what the schools agreed to with the athletes. I want to spend my money where I want to spend my money.
Gabe,
And
the skeletons in the closets that will come out,
yeah,
because in these conversations, you have general managers of the schools and other individuals employed by the schools who are sending out the package of NIL documents, including the MMR, and essentially, if not expressly, but at least impliedly, representing to the players that these are monies that they will receive. So, even if it's not a contractual claim, at a minimum, it seems like it's a strong promissory estoppel claim, because you have athletes that are relying on these promises that they're going to receive these monies. And if all of a sudden all of these deals are void, I mean, it could be a class action.
yeah, yeah. And then I've already kept you longer than I said it would, but I have one more topic I want to touch on with you. But before we get there, um, if you are a high school football star, let's say the number one quarterback or number two quarterback in a fictional world, right? I mean the real world, but a fictional person, and they are not represented by you, they're not receiving advice from you, so they're out there on their own, and let's say they don't care about the NCAA rules. They don't care about potentially being declared ineligible. They want to get as much money as they possibly can in 1 year, and they don't care where it comes from. What do you think realistically is a ballpark number that a high school football quarterback star who's being heavily recruited by these SEC, Big Ten, and again, not picking on any particular school, but given all the different ways of paying these athletes that you've talked about, which include these MMR deals, the direct payment, third party NIL deals, and maybe even some under the table money, how much do you think, if they wanted to push the envelope, the star high school football quarterback could get for 1 year from one of these schools?
To be clear, we're assuming it's the number one high school quarterback in the country.
Yeah. Yeah. Number one or number two. Yeah. Top, one of the very sought after, top of the top of the top.
I would say conservatively 3 million or more
3 million.
annually.
Yeah. But, and how much do you think that would come from the school?
Well, the answer to that really depends, because they have to manage the cap. And
Yeah.
so it depends on how much cap space that they have remaining, and when their fiscal year recycles, and how they can structure those payments from a timing perspective. So there's actually quite a bit that goes into it, which There's a reason why there's a justification of many other reasons why there should be GMs in the space.
Yeah.
But it's hard to say what the breakdown would be because there's so many different factors that would go into it.
But so you think like if they get 1 million from the school, you think they'd then only get another 2 million from the NIL deals and under the table deals?
I'm saying conservatively. I
Yeah.
actually think it would be more than 3 million.
Yeah.
I would say it's probably 4 million or north of that now.
Yeah. Yeah.
But I just I know we're speaking on the
Yeah, yeah.
record,
It's
so to
hypothetically.
say.
I get it.
So
I get it.
I'd
I've
rather be
asked too much.
conservative.
Yeah.
Yeah.
Yeah. Okay. So, last general question, with the athlete eligibility cases, the rule that's been on the books for a very long time that you have 5 years to play 4 seasons, now being challenged by multiple athletes, in primarily football and basketball, but other sports as well. And you are representing Charles Bediako, as I understand it, represented some other athletes. Can you explain? And it's complicated because it's really, I think, in some ways started with college hockey, where former professional hockey players were allowed to maintain their eligibility to play collegiately because of an antitrust lawsuit. And then it turns out that a lot of European players who were playing professionally in basketball were given eligibility to play in the US. And the rule has always been that you can't be a professional and then maintain your eligibility unless you're only being paid your necessary and actual expenses. So it's not really a payment, it's just allowing you to play that sport. The NCAA seems to have softened those rules a bit. And then sort of the next step was, well, if a European player can do it, why can't an American player? Why can't a player playing in the G League or potentially the NBA? And it's gotten now where we have lots of lawsuits. We have Bediako playing on, was it Saturday or Sunday? I forget which day it was. And there are a lot of people saying, well, wait a minute. If there's one thing many of us can agree on is that college athletes should be college athletes, and we don't want a 38-year-old student playing football against 19-year-olds. And the NCAA has said we're trying to put limits in, but every time we make an exception, it then gets sued to make the exception greater and greater and greater until we can't have any rules anymore. And if lawyers don't stop, then we're going to have a system where there is no limit on how much athletes can be paid, and there's no limit on how long they can have played. And so if LeBron next year decides, I'm done with the Lakers, I really have always dreamed of playing for Ohio State, I'm going to go back, and Ohio State can pay me 6 or 7 million bucks, or they can figure out a way, and I still have all 4 years of my college eligibility left. And I might take 5 years to do it, because maybe I'll redshirt in my junior year just to kind of go abroad or something. So what? Tell me about the Bediako suit, or just more generally, what
Yeah.
the argument is as to why those limits shouldn't be enforceable.
Yeah, I hear the LeBron example a lot, and it's like
Yeah,
obviously that just to be clear, that would never fly because he's well beyond the
yes,
4 and 5, and
yeah,
well beyond any exception related there too.
yeah,
Yeah, I mean the the problem is you said the NCAA has softened its stance, and the problem is the cat's out of the bag in many respects, and you can't put it back in. I mean, the problem that, and I think hopefully one thing that we can all agree upon, or at least the very reasoned listeners to your podcast, is that if the NCAA or any association is going to have rules, those rules cannot be applied arbitrarily or capriciously. And so when you start to allow for exceptions, and even when your rules expressly allow for exceptions, and you don't apply those exceptions across the board in the same way, or you have very clear exceptions to the rule, but you have a process that is behind closed doors in terms of the waiver process that a player cannot even bring on his or her own. It has to actually be brought by a compliance officer, and we have compliance officers around the country who are refusing to even submit waiver requests, which is in and of itself its own issue. But then the NCAA is essentially the judge, jury, and executioner in this process, and arbitrarily making determinations. That's why you have circumstances where myself and other lawyers are bringing suits. And you brought up the Charles Bediako case. You know, there. we refer to other athletes, such as James Najee, who was drafted in the NBA draft, and has played professionally. European basketball players, plethora of them, who have played professionally and then received eligibility. And to be clear, Charles Bediako is still within the 5-year rule. In fact, he's been ruled eligible under a TRO, and importantly, we needed it now because this would be his last season under the 5-year rule. So it's not as though we're trying to discard the 5-year rule altogether. But what we're saying is, how can you say that another player who's logged more professional minutes, another player who may have not signed an NBA contract. And by the way, Charles Bediako did not play a single minute in the NBA despite signing certain contracts that could deem that, you could characterize them as NBA contracts, but somebody else who's made more money professionally than Charles Bediako. How are you denying Charles an opportunity to go back to school under the 5-year rule and play when you're allowing others who have logged more minutes professionally and made more money professionally? Back to your comment about the exception, which is that you can play professionally as long as you're only getting paid, the reasonable expenses to cover, what is reasonable. Well, if it's reasonable for others who have received additional eligibility, but it's not reasonable for Charles Bediako, who's received less money, how do you defend that? And I think that's again an area that the NCAA is having a hard time defending. And then we can get into other cases. I mean, whether it's the JUCO rule, the NCAA gave a blanket waiver to a whole set of individuals who were the same class as Diego Pavia. Why did that class get an extra year, but no other classes get an extra year? And I think we're going to challenge that with Tristan Smith, who we just filed for a wide receiver at Clemson to get an extra year, who played at the same community college as Malik Benson, another one of my clients that got an extra year, was able to play for Oregon only because he happened to be in the same class as Diego Pavia. Where's the equity in that? How do you have a guy like Dr. Bradley who demonstrated real mental harm, and there's an exception of 5-year rule for that, and the NCAA said, well, we're just going to ignore that. And we're going to say he can't play. And that's where the NCAA is having issues, and that's why I'm taking these cases on. And I know I'm an easy target by doing so when you look on social media. But to me, I think we have to keep the NCAA honest. And I'm not saying that there shouldn't be any rules, to be very clear. They should just be enforced and treated. Every athlete should be treated the same way under those rules. And unfortunately, they're not being treated the same way.
So, so on that point, where the NCAA tried to declare Pavia ineligible, they didn't want Pavia to continue playing, so they try to stop him. He wins his lawsuit, and then the NCAA says, "Well, if we want to be consistent, we have to give a blanket waiver because otherwise we're giving a benefit to Pavia because he sued in this one particular jurisdiction." And so then they change those rules, and then you get the next lawsuit. And the lawyer argues, as they should, look, you allowed Pavia and everybody else in his class to play. Why can't the similarly situated athletes in the next year play? And then if the NCAA says, all right, we're going to try to stop that, and then you get sued and they win, how do they then draw any lines? Because
They
they would
didn't, yeah.
say, we'd love to do the 4 and 5 with no exceptions other than COVID and other than some extreme circumstances which are permitted under the rule. How do they maintain uniformity if they keep losing these lawsuits?
It's not the losing of lawsuits. The NCAA did not have to provide that blanket waiver. I was very happy that they did because it was actually in the wake of Pavia. And by the way, Pavia didn't win his case. He received a preliminary injunction. In the wake of that injunction, we were going to file a lawsuit on behalf of the aforementioned Malik Benson. And it was at that point in time that I was in communication with one of the NCAA's lawyers. And that's when they determined before we filed that they were going to provide that blanket waiver. I'm not sure they really thought that through because, in my estimation, it probably would have been wiser for the NCAA to allow me to file and anyone else to file and still fight against the Pavia decision, which I believe that case is still going on. And so it's not as though the NCAA waved the white flag on that case. I think the problem for the NCAA is the policy that was created by way of that blanket waiver. And again, if you're going to provide everybody in that class that extra year, then how can you tell the next class you don't get that benefit? What was the basis for providing it? Just that you were afraid of more litigation? I think that's not very persuasive to a judge.
Yeah, I just again in defense of the NCAA, if Pavia is ordered, or if the NCAA is ordered to allow Pavia to play on a preliminary level, and then somebody else applies, and the NCAA says no, they would get absolutely destroyed in the press for saying this has been ruled preliminarily to be illegal, and yet you're saying no again. So
Yeah.
it just feels like, again, back to that catch-22, not to defend the NCAA, but I'm not sure they had a winning answer there.
Hindsight being 2020, they would have benefited. I forget the name of the Supreme Court case, but that essentially said that rulings in one federal court don't necessarily apply to other federal courts.
Right,
I
right.
don't think they could have been Nostradamus and predict that. Although there were questions, obviously, which is why it ended up being a Supreme Court case as to
Yeah.
whether one decision would apply to another. But again, you still have cases that have come about in the wake of the Pavia decision. I mean, whether it's Patterson or it's Jet Elad and now Tristan Smith and others. So I don't know that they accomplished anything by way of creating that blanket waiver without then just saying, all right, anyone who played in JUCO, you get one extra year, because then you're just applying that same policy across the board. And that's my only point, which is that you have to have consistency in the application of your rules. And I can provide you countless examples of where there's just pure inconsistency.
And so the LeBron example, put that one aside, and let's
Right,
say it's
right,
Cooper Flag, and
right.
Cooper Flag says, "Look, I've only been in the NBA for a year, and this is not turning out the way I thought it would. Everybody's still chanting 'Fire Nico,' even though he's already been fired, and I want to go back to Duke because that was such an unbelievable year. Should have won the national title. We would have beat Florida in the finals. There's no question. What and look, nobody would argue that he's just making reasonable expense. He's getting paid a lot of
Right.
money, but that doesn't seem like they've narrowly tailored that rule to say we're going to look at the exact salary you're making. So if Cooper Flag called you and said, "Hey, I'd really like to go back to Duke," um, do you think you win that case by saying, "Look, he wants to go back to school. Why would you try to discourage someone from going back to school? And you've let all these other guys go back to school."
I'm not sure. And I will tell you, without mentioning names, I've been approached by many players that have logged either a small amount of NBA minutes to a significant amount of NBA minutes, but still fall within the scope of the 5-year rule, as well as agents. And we're looking at each potential situation and possible case differently. And going back to Damon Williams, just weighing the risks versus the rewards, and obviously the inherent costs associated with litigating and what that could mean for the player's true professional career as litigation plays out. And I think, as would be suspected, this sort of goes in steps. And so, I think at some point in time, whether I'm counsel or somebody else is, you probably will see a case that's brought by a player, a former NBA player who has logged actual minutes, unlike Charles Bediako. Um, I would suspect you're not going to start with someone like Cooper Flag, who is an integral part of the team and is logging minutes every night, every time that there's a game. You'll probably find somebody first who's played a few games to start testing those limits. And um, yeah, that could come. Whether I take the case or not, I don't know.
Right, fair, fair. And I don't want to read too much between the lines, but I think what you're saying is that you're going to represent Jonte Porter in his attempts to go back to college. That's a joke. It's a joke for
No comment.
everybody. But all right, last quick question. if you were the NCAA or the CSC or the conferences, what would you do to stop Darren Heitner and the lawsuits that they're facing?
I think it goes back to what I said before, which is spend the time to to craft the rule. I mean, throw away the rule book, first of all. It's too long, it's convoluted, it's tough to follow. I know there's been efforts to modify it and shorten it, but come up with rules that truly serve a pro-competitive purpose. Come up with rules that aren't overly restrictive, particularly in this world where athletes are making significant amounts of money. I mean, this rule book was created in large part pre-July 1, 2021, before anyone was making money from NIL. And so I think the NCAA needs to reconsider its rules, given that, because judges are looking at the rules in light of the fact that athletes are now commercializing their NIL, or even some judges realizing it's pay for play. Um, so I think the looking at the pro-competitive portion, restricting to the extent that you can the anti-competitive portion, and then even application of the rules. That's the big thing. Like you want me to not file a lawsuit on me. Like right now, I'm pre-suit for a player who was able to show significant mental distress, which is why he didn't play a specific season, which is an exception to the rule on the 5-year rule. You shouldn't force my hand and make me file that lawsuit. You should give him an extra year. And yet I followed up with the NCAA many times and I'm not getting any response. And I get it. They're busy. They're limited in resources. But, you know, yeah, if I have a JUCO case, make me file it. I get it. You're taking a firm position on that. But if I have a case where a player can actually show mental distress, why are you making me do that? And that's the thing. Like that's what the general public doesn't realize. I'm not out here just slinging lawsuits all over the place. I'm doing it after exhausting every effort to try to avoid doing so. And I wish the NCAA would do a better job of just giving me what I'm asking for when I'm not asking for too much.
Right. Yeah. That's uh that's well said, and I think many people have said for a long time if they had done that 10 or 15 years ago, we probably wouldn't be in the position we are now. But again, hindsight is 2020, and here we are. And I appreciate you taking the time. I kept you only twice as long as I said I would, but you could add it to my tab.
Yeah, the
But
fake one.
yeah, yeah. So thank you for doing this, Darren. I really appreciate it.
Yeah.
It has been fun, as I mentioned to you in DC last week. It's been fun to see your career take off like a rocket ship, and
Thank you.
congrats on all that you've done. And good luck, and love to have you back on as more things develop, because I have a feeling that
Hmm.
this is not the last time you will be making news.
Well, this is great. Thanks so much for having me, Uncle Gabe. And till next time.
All right. Thank you so much, Darren.
All right.
Be well. Thank you.